Should you put your adult child on your bank account? This issue comes up a lot with our clients. The most common scenario is mom comes into our office, she's getting older, and she's worried about becoming incapacitated. And she wants her adult child to be able to access her checks and pay bills on her behalf out of her account. The other concern mom has is when she dies, she wants her child to be able to quickly access the money to pay the funeral home. I want to start by talking about some of the fears people have around this issue, and then I'll talk through some options. The first common fear is, if the child is an authorized signer or owner of the account, can my child steal the money in my bank account? And the answer is yes. If that is a concern to you, you don't want to make the child an authorized signer or owner of your account. The next fear is, if the child gets sued or goes through a divorce, can a creditor take the money, or my ex-son-in-law take the money from my account because they are an authorized user or owner? Typically, if your child is an authorized signer and the money hasn't been commingled with theirs, a creditor could not get access in most states. However, in some states, if your child is a co-owner, the creditor or an ex-son or daughter-in-law could get your money. Finally, the question is around what happens to the bank account when I die. And that's when it can get really murky, especially if you have other children. For example, mom goes into the bank and she adds her daughter to the account, and she tells the banker, I want my daughter to have access to the account when I die. So the banker has the mom put the daughter as a co-owner of the account, and then the mom dies, but the daughter is one of 3 children. So typically that would create an issue because that bank account should really be split between all 3 of the children. If mom truly wanted that bank account to be carved out to just go to one child and not be split, she should design that in her estate planning documents. I think there's a lot of confusion around, should I make my child a co-signer or an owner? Typically, if you make your child a co-signer of the account, that gives your child access, and that access terminates when you die. Whereas a co-owner of the account really can subject the mom to the daughter's creditors and divorces. Now, the next thing people ask is, all right, I'll do a payable on death for the bank account, but that doesn't always solve the issue, because if you become sick or incapacitated, a payable on death is in effect. And also with a payable on death, the daughter doesn't get immediate access to pay funeral bills. Typically, they have to wait for the death certificate, which can take a few weeks. Another option is a power of attorney, so mom can sign a power of attorney and give daughter access if she becomes incapacitated. But banks don't have to accept a power of attorney, and banks often don't accept them if they are too old, for example, more than 3 years old. So what's the solution here for many of our clients? We often have them hold their bank accounts in a revocable living trust. Their trust has language that says, if I become incapacitated, my successor trustee, i.e. my daughter, can step in on my behalf. And when I pass away in the trust, you can designate, do you want the full bank account to go to your daughter, or do you want it to be split between your other children? In addition to that, I always have my clients speak with their specific bank about the bank's specific policies and procedures, because those can vary in a lot of different ways. So always ask your bank how you handle my account if I die or become disabled. And some banks may want you to sign their specific form to make it easier. For example, a friend of mine lost her husband unexpectedly a few years ago, and they had a joint bank account. Now, a few days after he passed away, my friend was at the grocery store, and the bank called her and said that they were notified by Social Security that her husband had died, and they needed to freeze that joint account until she could come in and move the money and fill out paperwork. This was really stressful for my friend, because not only was she grieving, but she was also at the grocery store with a cart full of groceries that she needed to pay for. Bottom line, you want to work with an estate planning attorney in your state to set up a plan that covers death and disability. You also want to speak with your specific bank and make sure everything is set up correctly to make it as smooth and easy for your loved ones. If this video was helpful, let me know in the comments, and be sure to watch my video on the 5 living trust mistakes linked here. I'll share with you the most common mistakes and how to avoid them.